As to question number 4, what is continuing guarantee and how is it revoked? So, as provided under section 129 of the Contract Act 1872, as regarding continuing guarantee, a guarantee may be an ordinary guarantee or a continuing guarantee. In case of ordinary or specific guarantee, the surety is liable only in respect of a single transaction, but in case of continuing guarantee, the surety is liable in respect of any of the successive transactions which come within its scope. So, a guarantee which extends to a series of transactions is called a continuing guarantee. And as regarding illustrations, we will discuss certain illustrations relating to continuing guarantee. For example, A, in consideration that B will employ C in collecting the rents of A's zamindari, promises B to be responsible to the amount of Rs 5,000 or rupees 5,000 for the due collection and payment by C of those rents. This is a continuing guarantee. So also another illustration, A guarantees payment to B, a tea dealer, to the amount of £100 for any tea he may from time to time supply to C. B supplies C with tea to the above value of £100 and C pays B for it. Afterwards, B supplies C with tea to the value of £200. C fails to pay. The guarantee given by A was a continuing guarantee and is accordingly liable to B to the extent of £100. And the number 3 illustration relating to continuing guarantee is that A guarantees payment to B of the price of 5 sacks of flour to be delivered by B to C and to be paid for in a month. B delivers 5 sacks to C. She pays for them. Afterwards, B delivers from 4 sacks to C, which she does not pay for. The guarantee given by A was not a continuing guarantee and accordingly he is not liable for the 4 sacks. So, there can be a continuing guarantee for a fixed period. Continuing guarantee in accordance with section 141 of Indian Contract Act 1872 would only mean a guarantee which only mean a series of transactions. Therefore, continuing guarantee speaks of continuing transaction, not the period of such transaction as it was held by the Calcutta High Court in 1986 in the leading case Eastern Banks Limited versus Para Services of India Limited and others. So, the very continuing guarantee also was decided in another important leading case, that is Bhavani Shankar Patra versus State Bank of India, and another in 1986 by the Odisha High Court, where it was decided while a mere forbearance to enforce the security against the principal debtor will not discharge the surety. Any act or omission by which the creditor loses or without the consent of the surety parts with the security, it has the effect of discharging the surety to the extent of value of security. Whether any particular act on the part of the creditor constitutes mere forbearance without move or constitutes an act by which the creditor puts it out of his power to hand over of security to surety will depend upon the facts and circumstances of particular cases, as it was decided by the Odisha High Court in 1986 in the leading case Bhavani Shankar Patra versus State Bank of India. So, now we'll go to how is it revoked. So, revocation of continuing guarantee may at any time be revoked by the surety as to future transaction by notice to the creditor. And regarding that, we'll discuss certain illustrations. For example, A, in consideration of this discounting at A's request bills of exchange for C guarantees to be for 12 months and due payment of all such bills to the extent of only 5,000 rupees. B discounts bills for C to the extent of 2,000 rupees. Afterwards, at the end of 3 months, A revokes the guarantee. This revocation discharges A from all liability to B for any subsequent discount, but A is liable to B for the 2,000 rupees on default of C. And another illustration relating to revocation of continuing guarantees that A guarantees to B to the extent of 1,000 rupees that C shall pay all the bills that B shall draw upon him. B draws upon C, C accepts the bills. A gives notice of revocation. C dishonors bill at maturity. So A is liable upon his guarantee. So apart from it, a continuing guarantee also operates revoked by the death of the surety. So, as provided under section 131 of the Act, the death of the surety operates in the absence of any contract to the contrary, as a revocation of a continuing guarantee so far as regards future transaction. The representative of a surety is liable for all transactions guaranteed by the surety before his death when the consideration for the continuing guarantee is indivisible. It cannot be revoked even by the death of the surety, and his estate continues to be liable for future obligation as it was decided in the leading case Hassan Ali versus Waliullah in 1930 by the Allahabad High Court. So, this is all relating to the question what is continuing guarantee as provided under section 129, and as we discuss all the illustrations relating to section 129 regarding continuing guarantee, so also the important leading cases like the Eastern Bank Limited versus Para Services of India Limited and others in 1986, the judgment delivered by the Calcutta High Court, so also the leading case Bhavani Shankar Patra versus State Bank of India and another in 1986 by the Odisha High Court, so also how is it revoked? That is revocation of continuing guarantee with illustrations, so also section 131 of the Indian Contract Act as regarding the very death of the surety, and when the very continuing guarantee is indivisible, how it cannot be revoked, as the very estate continues to be liable for future obligations as it was decided by the Allahabad High Court in the important leading case Hassan Ali versus Waliullah in 1930. So, in our upcoming video, we'll discuss regarding the very contract of surety.